Good morning, Your Honour. I appear on behalf of my client, Mr. John Smith, who is seeking bail this morning, Your Honour. Just some background to this morning's proceedings. On the night of Monday, July 30, my client was arrested and charged with causing serious injury recklessly, pursuant to Section 17 of the Crimes Act. My client is currently in custody and is seeking bail, pursuant to Section 4 of the Bail Act, which provides an accused person with an entitlement to be granted bail. Mr. Smith has no prior convictions or charges and has never been in custody prior to this incident. Your Honour, in arguing for bail, I make the following submissions: that the offence of causing serious injury recklessly under Section 17 of the Crimes Act is neither an exceptional circumstances offence under Schedule 1 of the Bail Act or a show compelling reason offence under Schedule 2 of that Act. As a result, my client does not bear the burden of arguing for his release on bail. Additionally, Your Honour, that my client does not pose an unacceptable risk under Section 4E of the Bail Act will become clear, and that the onus is on the prosecution to prove that he does present such a risk. Similarly, that the court must take into account the presumption of innocence and the right to liberty in accordance with Section 1B of the Bail Act. Further, Your Honour, that in relation to the unacceptable risk test, the surrounding circumstances of my client, which must be taken into account pursuant to Section 4E, subsection 3 of the Bail Act, are indeed in my client's favour. That, in support of the above, it is noted that my client has no offending history to speak of, giving weight to the submission that my client is highly unlikely to commit any offence while on bail, and therefore presents very little risk of endangering the safety or welfare of any person when granted bail. That my client is gainfully employed and provides for his wife and 2 children is also relevant, Your Honour. These personal circumstances and home environment indicate that he is both firmly grounded by his commitment to his family, as well as in turn supported by those family relationships. He is therefore unlikely to do anything that would jeopardise his freedom, such as interfering with any witnesses or failing to surrender into custody. That my client is born, Your Honour, raised and currently living in Melbourne indicates that he is firmly rooted to this jurisdiction, therefore buttressing the submission that he is highly unlikely to abscond. Further, Your Honour, that my client's partner is able to provide a substantial bail surety to the court, and that my client resides in close proximity to an operational police station adds weight to his application for bail this morning. Further, that my client is prepared to agree to abide by a strict curfew and bail is also relevant. Your Honour, it will be submitted by my learned friend opposing bail that he presents certain risks if granted bail. Specifically that my client presents a flight risk, as he is a qualified and licensed pilot, and may therefore fail to answer bail. To this I would respond simply by reiterating that Mr. Smith is grounded in Melbourne by his family, employment and long-standing connection to the city in which he has lived his whole life. Further, it's also relevant that he's not presently the owner of any plane and will tender any documents authorising him to pilot a plane. Arguably, Your Honour, therefore that risk is thoroughly mitigated. Additionally, Your Honour, it will be submitted by my learned friend that my client is associated with a certain figure in Melbourne's gangland crime scene and may therefore engage in criminal conduct or otherwise harm the community. To this I would respond that my client has had minimal contact with this individual in recent times, and that said individual has no influence over my client in his current life as a 30-year-old husband and father of 2. Finally, Your Honour, it may be said that the case against my client is strong given the presence of witnesses, for example. However, it's worth reiterating that my client is still, of course, entitled to the presumption of bail. Simply having what may appear to be a strong case against a bail applicant does not rebut the presumption, Your Honour, that that applicant should be granted bail. In summing up, Your Honour, I will simply say that my client remains in custody, even though he has never before been in custody and never before been charged with any offence. that my client is gainfully employed and supported by his wife and is the father of 2 young children, that my client is entitled to bail, and that my client is prepared to abide by strict conditions imposed by the court this morning, Your Honour. Thank you.